Disclaimer. Judge Ron Rangel is providing this podcast and website for educational purposes only, as well as to give the public general information regarding topics related to the criminal justice system. The views, thoughts, and opinions of his guest speakers are the speaker's own and do not represent the views, thoughts, and opinions of Judge Rangel. All rise. You are now listening to Beyond the Gavel with Judge Ron Rangel, educating the public and expanding mindsets. Subscribe on our website, beyondthegavelpodcast.com, or your favorite podcast platform for more of the latest podcast episodes and updates.
Welcome to Beyond the Gavel with Judge Ron Rangel. I'm your host. I'm here talking to Jonathan Watkins in part 2 of this particular interview. Jonathan?
How are you, Judge?
I'm doing great.
It's so nice to be here.
Agreed. When we last left off, we were talking about inadmissible information that comes in during the trial and the judge having to instruct the jury to disregard certain things. To me, the interesting part of that whole thing is that, frankly, somebody could say something that's absolutely terrible in court, right? Somebody could say, blank existed, even though a judge instructed that witness not to say this. A judge could then turn to the jury and say, I'm instructing you to disregard the last comment made by this particular witness. And the law basically states that a jury then is supposed to disregard. And so some folks argue, how can you unring that bell? It's not an automatic. There have been situations where something seems to be so violative of some fundamental right that kind of an instruction will not cure that particular issue. And I'll give you an example. We were in a trial at one particular point in time, and somebody was being interviewed in the witness room by the police. And they basically said, I'm not going to lie to you. I've been to prison before, right? I get this game, right? And so that in and of itself is not something that the jury's supposed to know, particularly during guilt innocence.
Right.
That part's supposed to be cut out of that particular affidavit or that particular statement, the recording, because that would be a violation of somebody's right to be presumed innocent. And so as a result of that happened. It was supposed to be cut out of the video. The prosecutor played the wrong video, right? They played the unredacted video. I turned to the jury and I instructed them to disregard. The parties approached. The defense said, frankly, that's not something that can be cured. And I agreed with that, right? So it kind of depends on the level. And so in this case, a closing argument related to 15 years not being enough was not enough of a substantive violation, somebody's substantive rights to overturn that. So it was considered to be harmless.
You're correct. Yeah.
Yeah. Well,
so it was still an error, but then they were like, well, it was harmless error.
Right. Because of the instructions.
Funny that you mentioned that. And I have been blessed to try a number of cases at this early stage of my career. But yeah, you're right. And it works. I think it works on both sides of the table because some defense attorneys have a strategy to just get the question out there, right? Like even if it's inflammatory or if it's prejudicial or designed to confuse the issues, all that stuff, they just want to get the question out there and they want it heard. And you can do a motion for the jury to disregard, but then there's human nature. Are they really going to disregard that? And it reminds me, I'm not trying to be too comical here, but it reminds me of the movie My Cousin Vinny, where Joe Pesci goes to give his opening statement. And he was like, yeah, everything that guy just said is BS. Thank you. And then Fred Gwynn says, jury, you will disregard everything that was defense counsel said except for thank you. It'll be stricken from the record.
And it was stricken from the record. That was a really good movie. And a lot of what was argued in that, and obviously there are things in all these movies that aren't going to follow the exact procedure, right? The way the evidence is supposed to flow, the introduction of evidence, the type of cross-examination and all that, obviously. But overall, I think they do a pretty good job, these kind of movies. They do a pretty good job in depicting the process and how things work, and right.
Oh yeah, and expectations of we're still in South Texas, and you're expected to dress appropriately for court, and to know the local rules, to know the basic. There's an expectation of decorum, I believe.
Yeah. Let's talk a little bit about your client, Anton Harris. I mean, who was he? Right? We know he was this kid. What was the deal with this situation? Why ag sexual assaults? Why these types of crimes?
Scariest thing, Judge, is he was nothing but graceful and respectful to me, polite, soft-spoken, and young. The youth, you could tell, hey, this guy's still a kid. He was 18 when he was arrested. In fact, they arrested him 2 days after he had walked the stage. He was the star basketball player at Marshall. There were talks of him potentially playing like a JUCO ball, like junior college, or a D2 ball. Like he was a star athlete. He was an all-city player, had a girlfriend. I believe I'm not sure if she was in band or cheerleading. She was a popular young lady, very polite young lady too, very well-spoken. But, he had we did some investigation into his background, and he had a pretty tumultuous childhood. His father at the time, his father was in Detroit, Michigan. The mom and him somehow, they break free from that. But I remember he was sent back to live with as punishment, he was sent back to live with his dad, and he kind of lived the good life in Detroit. But his father was later convicted of distribution of narcotics, federal charges, so his dad was into the drug dealing game at one point in time and may have provided for them, but are you really being a father figure? So I think there was some developmental issues. And overall, when I look back on it, it's like you think of the theme of control. Like, this stuff only happened at night. And like the only thing I can really say is, in my opinion, there must have been some type of switch that went off. And I do believe that the family issues and the developmental issues growing up attributed to whatever, became of him. But then you're dealing with a Dr. Jekyll and a Jekyll and Hyde situation where you have one coin, but it has two sides. Mm-hmm. And there's one side of that coin is just pristine. It's shiny. You can see everything. You can see what year it is. You can see the insignia. You can see the flag. And then the other side of that coin is just covered in mud that is an inch thick and that you're just clawing to get off. It's just dark, grimy, dirty, and just it's just so hard to even fathom how that's the same coin that you flip over.
Yeah, and a lot of what these experts that come in and testify in these aggravated sexual assault trials say is that every situation is different, and you can never paint this broad brush and say that all of these offenses take place for a certain purpose or a certain reason. But generally speaking, a lot of these things are not necessarily related to some sort of sexual appetite. They're related to control issues.
Correct.
Yeah.
And that was demonstrated in this case with the evidence with knife point, gun point type commission of the offense. It's not like he had the gun and pointed it at them and said, hey, go to the bedroom. One young lady had a gun to her rib cage, and the other young lady had a gun to the back of her head while the rape was being committed.
I'm not saying necessarily that this is applicable here, but you made reference to two sides of the same coin being so different. Reminds me of that movie. And since we're on the topic of movies, since we're on the topic of the arts as it relates to the law and these criminal or real crime type trials that take place in these movies, there was a great movie that I saw back in the day. I don't know if you ever saw it. It's called Primal Fear with Richard Gere and Edward Norton.
Oh, yeah.
That was an excellent, that was one of those.
Oh, my goodness, where he represents the guy, and then the guy kind of like elaborately lays out the whole thing.
Yeah.
Was it an insanity defense?
Yeah.
And it's just bone chilling. You're just like, you're shook after you see the end of that movie.
Yeah, because it's like the guy that you saw was not the real me. This is the real me.
Yeah. And in that movie, if I recall correctly, Richard Gere was a suave, charismatic, very collected and confident advocate. Like he was the guy you went to. He was the big, kind of like you think of like a Mark Stevens or a Goldstein. Like he's the big guy on campus.
Why is it specifically that this investigation took so long? Is it because nobody could exactly identify who he was?
Yeah, he had just kind of like slipped under the radar. And that was, manner and means, I'll say. Mm-hmm. I think where he got tripped up was when this whole thing happened where he tried to commit an offense and was unsuccessful. And then this lady was like, yeah, it happened to the Bolero. And I think that they had like a 3 or 4 hour window, and then they just run the camera and then they get a still and they're like, young black male, thin. And he wasn't wearing anything to cover his face.
We got you. So that's how they got the facial description.
Yeah. And then that's how they were like, oh, this is Anton Harris. So then let's go check out Marshall High School and let's start watching him. Let's start, surveilling him. And then eventually let's get this straw. And then that was the straw that broke the camel's back.
You mentioned a buccal swab and the ability that authorities had and experts had to tie in his DNA with that of the perpetrator. So what I get out of that, and I'm sure a lot of listeners are getting out of that, is that when he had sex with these with these ladies, he deposited semen.
Yes, sir.
And so the DNA that was found to or not be excluded was from his semen. And as a result of that, what would have happened if he would have worn protection or a condom or something when he committed these crimes?
That's a very, very, that's a scary notion there, because we actually had like I said, we had a forensic chemist, Dr. Benjamin, on the case, and he had kind of, tossed ideas back and forth with me. And that was an idea I took and extrapolated. And basically, had he worn protection and had he not ejaculated, or had he ejaculated in a condom, right, there's a really good chance they would have never got him. Mm-hmm. The investigation could have been even more prolonged. There might have been another victim, right? Mm-hmm. That's the way you could also think of it.
Was it contemplated somehow that somehow or another it was purposeful that he did not use some sort of protection in that way? Or
I think that it was, if just based on all the kind of the reports and like the common trend of the offenses, they were pretty quick episodes. Like one episode lasted 1 to 2 minutes. One was like 5 minutes. Like he was never really like, spending a prolonged period of time with the victims. Mm-hmm. It was just kind of a quick thing. And then, he'd run out and he'd tell them, don't call the police or don't go anywhere. And at least in 2 of these reports, Judge, the victim in the 2 different cases, a victim was at their home. They were accosted by Mr. Harris. The rape was committed. And with 2 of those victims, their boyfriends were on the way over to visit them. So then there's like that element of timing. Like, what if one of these boyfriends had made it home to intercept him? Or, could that have led to his apprehension a lot sooner?
Which was absolutely coincidental, right? That was not
correct. Yeah.
There's an issue in this case related to the plea, right? Wasn't there some sort of plea that you had an agreement with the state, which the judge ultimately rejected?
There was, yeah. So Ms. Guerrero and I worked very diligently to work this matter out. Mm-hmm. And this was a case where both sides knew, I think that the state judge, it was north of like 60 witnesses, maybe north of like 70 altogether. Mm-hmm. The trial was 10 days. I want to say it spanned over 3 weeks. It was a pretty big undertaking. And I think that with both parties wanting to negotiate and work the thing out, there was a lot of media coverage, but what the general public fails to appreciate is that most of these women, they don't want to relive this experience, just straight up. They don't want to have to go in and face their accuser because there's trauma, mm-hmm. there's PTSD, there's all sorts of issues going on. At least one of these young ladies had a Labrador, like a service dog, because she already had anxiety before the attack occurred. And guess what? That spiraled into depression, major depression, increased anxiety. So she eventually had to get a service dog as a result of this. And what a very we were really polite to her. But back to what you're saying, it's tough. It's tough on all ends of it because there is an impact, right? So the parties are working to work it out. And then we had come to an agreement on 40 years, okay, on one of the cases. Then, this, we call it the PSI or the PSR, the pre-sentence investigation. Mr. Harris himself had said some things to the probation office.
And he was a prosecutor, Mr. Harris.
Daryl Harris, yeah. No, yeah. So there's 2 Harrises, but Daryl Harris and I had agreed to 40 years. And I think if I'm backtracking to what I'm saying is that if you're the state, if you don't have to call these witnesses one by one to relive that experience, and if they're okay with a 40-year sentence, or if you've run that by them, then you've done your due diligence, right? And maybe you save a lot of time and resources of the court and the public. So we had an eye to work it out. And 35 years was the year, that was the number I was striving for. We settled on 40. And Monica and I talked to the client. We explained to him, like, hey, look, because if you're doing the parole thing now, you're like, okay, well, 20 calendar years, and then you're eligible. We can't discuss anything else. We can't give you more points on it. Like we just discussed right now, parole is unpredictable. But what had happened was in that pre-sentence report, our client, Mr. Harris, AJ, had made some statements that were statements of denial. So then Judge Castro took that as a denial of guilt. And in order for most courts to accept these plea bargains, it's like a judicial confession. It's like
I gotcha. That makes sense. Because then later there could be some sort of writ that is filed that says that, hey, he didn't actually admit that he was guilty. He actually was denying it. And he could say somehow or another he was forced to take that plea.
Coerced, yeah.
Yeah. And so regarding plea bargains, it's also important, I think, for folks to understand that we know that parole eligibility, and I read the language that we talk about in sentencing in the charge to juries. Parole eligibility starts at 30 calendar years or half the time. whatever is less. So we know within the system that a sentence of 60 years on up, parole-wise, isn't going to make a difference. And that's a very different lifestyle inside the prison system than it is outside, right? The lives that folks lead is a lot harder. And so as a result of that, generally speaking, there's a tendency within the system of those that work in punishment to think that a 60-year sentence on up, there's not a whole lot of difference, right? There's not a lot of difference between a 60-year sentence and an 80-year sentence, or a 60-year sentence and a 99-year sentence as it relates to actual time served and the time somebody is going to be punished. And so a 40-year is what tends to be the cap for these types of first-degree felonies for when somebody wants to enter into a plea bargain, because why would somebody enter into a plea bargain of what they're probably going to serve max anyway after a jury trial? And secondly, jury trials are such a crapshoot. You never know. We have had cases where staff in the courtroom is thinking in their heads, and this is across the board. I think this is in all courts across America. They're thinking, this person is absolutely going to be found guilty by a jury, or they're thinking, I cannot see how a jury is going to find this person guilty, and the opposite result occurs. It's like, how could this have happened? People walk away stunned, but it's because 12 people are looking at this thing with their own individual independent eyes, and anybody else who's observing has their own eyes and looking at these types of cases. And then most of the time that there's a jury trial, it's not just a question as to whether or not somebody is guilty or not guilty. What's the appropriate sentence? So somebody could be found guilty, but maybe somebody on that jury could be looking at this young man's youth and say, this is a high school person. Maybe he's salvageable. Maybe we only want him to do 20 years in prison, right? And then that would then influence the entire composite of the jury and bring that overall sentence down. So it's always such a risk on both sides that there is always this idea that if you enter into some sort of plea bargain, you're removing the risk, you're saving the traumatization that these victims are going to have to go through. And sometimes they just don't want to testify. Sometimes they're saying, I'm sorry, I'm not going to go through this.
I've had that happen as a former prosecutor where we have to issue subpoenas, or where we have when I was working the family justice unit, it's like, those are the hardest cases, because typically if you're talking about family, you don't want to prosecute your family. Maybe something malicious may have happened, but let's let bygones be bygones, or he's gotten better. He's not been aggressive, but you got to issue a subpoena. And I even had to do a writ of attachment, like where a subpoena is issued, they're ordered to appear, they don't appear, and then you file a motion to have, a judge basically sign a warrant. What is similar to a warrant for the constable or a sheriff's deputy to go get the witness and bring him into court. I've had that happen. And the phenomenon of the verdict is a very real one. I've sat on many trials, and even as a prosecutor, I had some cases work out with a plea, and then I talked to the jury afterward, and I'm like, as a DA, I was like, we had this guy. And then, this juror tells me, how did she live her life? She had 3 kids and she was only 23 years old, and they're just fixated on some issue that's totally separate and apart from, did he do it, yes or no? And that has an indelible effect on what their verdict will be. And you may completely misread it.
Mm-hmm. Yeah. The media really played a role in this case. I do specifically recall that level of panic and fear, and I felt it, right? I felt like, oh my, there is somebody that is committing sexual assaults on females in the medical center area. I felt anxiety from that myself when I read that. And I was a judge at that time already, right? So how did the media fit into all this? Such a high profile case, which started from the public perception of the offense, which went all the way through jury selection, which lasted through the end of the trial. How did that affect your strategy? How did that affect the case in and of itself in the way that it was tried?
Yeah, it was really tough. Basically what I'll say is we did everything we could for Mr. Harris. We looked at the evidence, we dissected the issues, but that's something that on top of a voluminous package of evidence and boxes of, this was like, I think 5 boxes of evidence.
Mm-hmm. Which is a lot. That's huge.
It's a ton. We had to get external hard drives that were like, I think 100 gigs in order to have one for Monica, one for myself, in order to have a transfer of the electronic discovery. So it's just because it did stretch out through all the years. I think back to the media, to answer your question, this was, I don't want to don't quote me on this, but sort of was a case of first impression. Like this city received shockwaves from this news, and the continuation, and then the media reporting on now he's using a gun, like the escalation of the violence. And, it's a scary notion, because you're like, okay, well, crawl, walk, run. If we think about that in the context of the increased aggression of the offenses, would somebody have eventually been killed? Or had one of these victims tried to fight back, would they have gotten stabbed or shot? Like it's speculative, but it's just, human nature to think like about the what if. So I think that we hadn't seen a serial rapist take the city kind of by sweep the city like that. And, we do live in a world now, Judge, where, and I know you've been practicing a little bit longer than me, but where, this technology thing, it's a double-edged sword, right? It's like, it's not that hard for somebody, if they wanted to, spot you, follow you,
right?
Figure out what your patterns are, where you go and all that. Like in today's society, you can pick a beat on anybody.
There's no privacy.
Yeah, it's
at all.
It's just so that, but I think that compounded with the fact that this was a highly populated area with a lot of, like you said, young students, young females. It just put everybody on the edge of their seat. Like, holy crap, I need to not go shopping. Like, you almost have to, if you're a female, right? And I'm not a female. I don't know. I haven't walked in those shoes, but I can only imagine being a young woman at the time that this stuff was going on, who lived in the medical center. You're thinking, I'm going with group. We're going to go to HEB together as a team. We're not going to shop at night. Lock your doors. Just because, some people, they operate that way. It's like, oh, the door's cracked. Like one of these victims, she had an indoor-outdoor cat. So she heard the scratching at the door, and she thought, oh, I need to let my cat in. Something as simple as that. You think she had her door locked? No, she just went up there, popped it open, and boom. So I think it was kind of like a case of first impression for the city. Yeah. And I just think that the escalating nature of the violence really just had everybody on the edge of their seat.
Oh, the effect on the community consciousness had to have been severe. And you're right. We know that females go through a different type of life experience in a sense that it's unimaginable. It's unimaginable what that must have felt like at that time. Well, at any time, to know that these types of crimes occur.
Yeah.
That's it, right? Jonathan, this is a great conversation. Let's go ahead and cut for a quick Q&A break. We'll be right back.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome to Q&A break. We have a question. What liberties are you granted as a judge that regular citizens don't get? That's an interesting question, Jonathan. What are your thoughts about that one?
I believe that you could have designated license plates that indicate you are a public official.
Yeah, that's actually a very good response. Back when I first became a judge, it was very common, right? Somebody that drives through the parking lot where the judges park, that's all you would see are license plates that have the judges being identified as a state judge.
Correct.
That's not so common now. Since that time, I've obtained other vehicles, and I've never gotten that judge plate since then. It is not so common because I think now judges are a little more concerned about things like safety, things that didn't exist back then.
And that's a very interesting point that you mentioned that. And I'm not trying to be morbid here, but wasn't there a judge that got into an argument with the sheriff recently? It might have been in a different state.
That's right.
It was a district court judge, and he was killed.
Mm-hmm. Right. That's an interesting one. There's also immunities that apply. In some jobs, somebody makes a mistake, theoretically, they could get sued, depending on the level of culpability, depending on expertise and all the other issues. For judges, if a judge makes a mistake in judgment, generally speaking, as long as they do it in good faith, as long as it's not something where they're trying to do something inappropriate, they're granted immunity for the decisions they make on the bench. Let's say that there was an individual that was applying for probation and he was a dangerous person or she was a dangerous person. The judge gave that person probation in good faith. Person then commits a crime soon after. The judge then has immunity for making a judicial decision in good faith on the bench, part of their job, without having to worry about being sued for letting this person free.
Like civil damages.
Exactly. That's an interesting.
I think that makes perfect sense. So, I mean, you want to give the court a broad range of authority to make independent calls. I think that's part of probably what you take home. That's one of the more challenging parts of your job, is reading some of these sentencing reports and kind of calculating a solution in your mind that is fair to society or to the community or to the victim, but also fair to the defendant.
You always want to be fair, right? That's the part of the balance that we talked about.
Yeah, and that's interesting, but it makes perfect sense to me.
That's a good question. Keep those questions coming in. We really enjoy answering them. Head over to beyondthegavelpodcast.com to send in any other questions that you might have. Let's head back into the show.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome back to the show. I'm here talking in this episode with Jonathan Watkins. What's it like to be a lawyer in this type of a high-profile case, right? Is it risky to your career? Is it something that would be a benefit? Get your name out there? What's that experience like?
This was a whole new experience for me because I had been a part of a prosecution where I'd been on the news before for like an injury to a child case. I did a murder case with David Martin. It was the first felony I ever tried. That was on the news. A lady was stabbed in the heart, like on Mother's Day weekend. It was terrible. And that guy was a menace. He got 40 years. But, you know, when the cameras are there and they're asking for you to talk to them afterward and like, hey, give me your opinion on this, it's kind of like frightening as a defense attorney because you don't want to, ethically too, you don't want to overstep your bounds. And attorney-client privilege, you want to make sure that you're walking a straight line there. You're not, oh, well, yeah, I met with my client at the jail yesterday, blah, blah, blah. You don't, no. So it's just, it amplifies the duty. I feel like it makes your duty a little bit harder to just assess and then to answer the call of duty, right? You have to like just really dot your I's, cross your T's, right? Like, it sounds simple, but yeah, you really have to. And I think it was a new experience for me. I think I had ran late like a couple of times or something. And Judge Castro got a little upset. He may have said something that was off the record, but because the media was there, one of the news outlets had tweeted defense counsel running 15 minutes. Like, it may still be out there, but I just was like, wow, like this is not, it's not just about me. It's about this young man getting, like I said, a fair shake in the process and a fair trial. And it's about the community too, because they want answers. They want justice. There were just a lot of moving parts, but yeah, having the media there, I will say this, it amplified things, but it also got me to like really appreciate those people like Elizabeth Zavala.
She is top of the line.
And even the cameraman too, like just, those people are just true professionals. And like, you know what, Judge? It's exhausting. You know how it feels to be in a trial. It is mentally and physically exhausting. Even if you're just sitting down, I know you know this feeling. You get home, you might eat something and you just want to lay down.
Absolutely.
And you don't want to talk to anybody. You don't want to text back. You don't want to email back. It's a level of stress that's pretty high. But I got to see those people and they were so committed to providing the public updates. When you're in a courtroom all day long, you're carrying a camera crew and walking back and forth, it's a lot of energy that's being expended. So yeah. I will say this, I just have a lot of respect for those that work in that field.
Well, I talk to Liz all the time and I'm always, I tell her, it's amazing to me how she can boil down something that is a complicating issue and write it in a way that is so understandable, so explanatory. She really wants to get into the weeds in terms of her understanding of it, but the explanation is always so relatable. It's a real skill, and I think we're very fortunate to have those types of folks work in our media. And you're right. You're carrying a practice, right? You have nowadays attorneys got to have 100 clients at least in order to run a good business, and so you got tons of other clients that need your attention, that are trying to get a hold of you, that are upset probably because they called you 5 times during the day, not necessarily focused on the fact that you were in a high-profile jury trial and they hadn't heard back from you. I went through that experience as an attorney, and so that had to have been difficult.
Definitely, yeah. It's kind of like divided attention. You're right, and you, as an advocate, you want to have a certain level of quality with your service, and hey, I'll just say this for all of us. Hey, when we're in trial, that is the one thing we need to be focused on. because there are just so many consequences and so many, and like you're talking about a person's liberty. So somebody's life is definitely in the balance with your trial case. So, and I think that just the prolonged nature of the trial, like, yeah, we were in trial for 3 weeks. Like I said, I had told you earlier, Judge Castro did take a recess for a day, and that was to honor the late Judge Olivari.
Yes. I remember that. I miss him. He was an excellent judge. He was a good friend. I think about him actually quite often.
He was probably one of the sweetest persons I've ever met. I got to meet him through Roland Ramos, and just, you want to talk about that whole, like, don't forget where you came from?
Yes.
That was Ray.
Good human. He was a good human. What about you personally? What did you feel any risk to you? I mean, were people in the community somehow or another looking at you like, what are you doing representing an individual like this? Or did you ever feel that?
I think that in like my inner circles, there were definitely people who had questions like, what are you, doing, or how can you, and it's that classic, like you're just like in the crosshairs of like, I need to be focused for my client and I need to do my best for my client versus like, hey, like, look at what they're saying your client did, kind of like almost like trying to guilt you or shame you for doing your job. And that's the cross that a lot of us have to carry, is that, and I spoke about it earlier when I was talking about your moral compass, or your, keeping yourself on that tightrope, right? Keeping yourself straight. I mean, how can you not offer your best for somebody who everything's on the line? And again, it's just holding the state to that burden. You have to hold the government and the prosecution to that burden. But personally, yes, I feel like with the trial, for sure, my life was on hold for those 3 weeks leading up to the trial too. And this was a pre-COVID trial. Like, we tried it in January and February of 2020, right before that. So I could only imagine, like, had this thing extended past March, I don't know when it would, maybe we wouldn't be talking right now because the appeals are still ongoing.
This is an adversarial system. So I've always looked at it like truth emerges when both sides give it their all, right? If Mr. Harris didn't have advocacy that gave it their all, then the end result is going to be imbalanced, right? That's fairness. When you think about justice, the best way to define justice is thinking about what is fair, what is balanced, what is equal, what is ethical. All of those things have to come into play. And when a jury hears from both sides, and a jury hears things like direct and then cross and then argument and everything related to what goes into a trial, in the end, the only way you'll get that fairness is if both sides give it their all. And that's just the way it works. If you have one side that is much more superior as it relates to advocacy, you're not going to get a fairness in that.
No, you're not. And again, this was another case for me if you're talking about the attorney element of it, like what a blessing to be able to try a case with somebody like Elena and Daryl Harris, who are two of the most seasoned prosecutors in that office. But also too, Daryl Harris, I mean, tough guy.
Yeah.
Got the suspenders on. He's got his game face on. I feel like he's like a linebacker and I'm like a scrawny little running back, and you got to go run through that.
You're like the Rudy.
Yeah.
You're like the Rudy of the courtroom.
Judge, I had a dream and I made it come true. But I do agree with that. The adversarial system and people having advocacy. And I think that's what the public needs to appreciate a little bit more.
Absolutely.
I'm not endorsing what allegedly may have occurred. I have a very specific role in this process, and I need to show up for my client. No matter
you're making the process fair.
No matter what you think, or no matter what KSAT is saying or commenting. And I think that's where we get lost. Too many of us are, get caught up in the minutia or like fluff or the noise. And it's like, hey, you got to separate all of that and you got to be locked in.
I tell folks it's very, very rare, exceedingly rare to see a case that is somehow or another overturned on a mere technicality, or somebody gets away with committing some heinous crime on a technicality. People have a perception of the system that it is so filled with technicalities that folks that do really bad things are generally getting off. And that's not really something that we see all the time.
No, I don't think that it is common either. I think that, like you said, the truth usually will come out,
Yeah. The rules are there to make it fair. Well, what was the ultimate outcome? What did the jury decide as it relates to Mr. Harris's sentences?
Well, and I want to take this opportunity to actually thank the people who served on that jury. Mm-hmm. Again, my numbers might be a little off, but they had nearly 200 exhibits tendered to them.
That's a lot, yeah.
They had, I believe, 70 plus witnesses.
That's significant.
For sure. Somewhere in that neighborhood, 60, 70 witnesses. It's just, to devote your attention and to put your life on hold, to deliberate over, and to be an active part of our justice system and to uphold your civic responsibility. This jury also, Judge, deliberated for 5 hours and 27 minutes approximately, which, what does that tell you? They actually deliberated. They reviewed some of these exhibits and then they came together. Ultimately, what they did was they found him guilty. I believe we did jury for punishment, yes. And then there was count 1 of that indictment may have been the aggravated robbery, which occurred in the same transaction. And then count 2 was the aggravated sexual assault. And the case that they went to trial on was the final offense he was accused of committing. So it was like...
So it was one complainant.
It was one complainant, yes, that went to trial on that one. So he got 60 years. The jury gave him 60 years on the aggravated robbery and 99 years on the aggravated sexual assault. So pretty much a life sentence.
So because they were able to do that in punishment, that tells me that they were able to hear from some of the other complainants?
Correct. So that was what made the trial a little bit longer, was that it was multiple cases within one case. And I think they did that. That was wise of the prosecution. If you're looking at it from a prosecutor's perspective, we had discussed earlier some of the trauma or PTSD that some of these complainants may experience. You don't want them to relive it. Let's just get all of that out there and on the record in the punishment phase. So they even called the lady from the groping incident when that occurred, the extraneous misconduct, which she was never charged for, which is, again, something the public has a hard time wrapping their mind around. Is, look, there's guilt, innocence, number one, and then if he's found guilty or if she's found guilty, now we can get into the skeletons that are hiding in the closet.
So for folks to understand how this works, if you would have been found not guilty on these 2 counts, then the state could have tried the other cases individually. Right. And then let's say that if they decided to try a second case individually and he was found guilty on that, then because if it's a sex case, then that could have been stacked. So he would have done an entire sentence on 99 years before he would even begin the sentence on the second case, if it was a 99-year case as well, right? Mm-hmm. Okay. Well, that makes sense. Any other thoughts related to this trial that you would like to get our listeners to hear? I appreciate you hosting me on this podcast, sir. It's just been an honor to get to know you better and to look up to you. And like I said, I started as an intern at the DA's office, and then I was blessed with the opportunity to help this young man. It is a process that is really hard to describe in words, and it is a very huge responsibility. And I just think you have to take that calling seriously. So yes, I got to thank my team again: Johnny Whalen, Christian Vega, obviously Monica Guerrero, who is just a bulldog in the courtroom. And she shows up, and you know that she has to try some of the hardest cases. Absolutely.
At that time, what I learned was that she would get people who had 2 or 3 appointed attorneys before, but you're talking like capitals. You're talking like continuous sex abuse, aggravated sexual assault, these types of cases, which they are emotionally layered too. So there's the legal analysis, there's the fact reviewing, there's the preparation of the witnesses, looking at the witness list, exhibits that each witness has, and then there's the emotional element too. And I will say this, I'm very blessed that I do follow a healthy regimen and routine, because you got to keep yourself good if you're going to be, good for others. And I may have taken, a few weeks off of the workouts when this trial went down, but I still, managed to, get myself through this, to work hard for my client, and then to keep myself as healthy as possible. And I think that's a big part of it too. You
got to take care of yourself. Absolutely. And when we talk, I love hearing those stories about your experiences taking care of yourself.
Oh, the cold plunging, Judge, you got to try it.
Yeah, we've talked about that. I do agree. I'm going to try that. I don't know if I could do the mountain climbing with you.
Oh, you could do some hikes You can go to Colorado. There's plenty of places to hike in Colorado. You're already at elevation. Just, we all start with a journey of 1,000 miles starts with one step.
That's beautiful. That's beautiful. I've enjoyed talking to you. It's been lengthy. You've given us a lot of your time today. I really appreciate that.
Oh, Judge, it's been a true pleasure. I'm just so blessed, and I hope that your audience gets the most out of this, and just thanks for having me. And I appreciate what you're doing for our community and your level of educating others on what goes on behind what really happens in the courtroom, and how this quotient for justice that we're all after, trying to make sense of that, I guess, for lack of better words. I'm just very honored to be here. I'm It's been a very special time. And Judge, we can talk anytime. And I know we can talk about a number of things. So I appreciate you.
We're very fortunate to have had you on the show. Apart from the fact that it's an extremely interesting case with a lot of interesting legal analysis that goes into it. But I think you've been a great guest. I appreciate you coming on.
Muchísimas gracias, señor Juez.
Well, the honor and the pleasure is mine, Jonathan. I've really appreciated you being here. We've reached the end of this episode. Thank you, listeners, so much for tuning in. Don't forget to subscribe and keep sending in those questions. Remember that you can now text the show by clicking Text the Judge to send in your insights, reviews, and your questions. I'll make sure to mention them during the break. We'll be back with a new episode in 2 weeks.
You've been listening to Beyond the Gavel with Judge Ron Rangel. Join us in the next 2 weeks where we are educating the public and expanding mindsets. Head to our website, beyondthegavelpodcast.com, or your favorite podcast platform to subscribe to the latest episodes and updates.